Welcome to The Property Planet, a podcast with Simon Howley and Amanda Perrotton of Bell Howley Perrotton, the show all about the tax and legal issues surrounding property ownership, where we discuss everything that affects property investors and developers and go deep into the details to unravel the advice, highlight the traps you can fall into and dispel the myths surrounding property ownership in the UK.
Welcome to The Property Planet, the podcast where we look at complex tax matters and how to avoid getting yourself in a mess. And with that in mind, we're delighted to welcome Simon Nosworthy today, who's Head of Conveyancing for Osbornes Law in Camden, top legal 500 firm. So we're privileged to have him here. So welcome, Simon.
Lovely to be here, thank you.
The idea of our chat today really is to look at why I want the audience to listen to another solicitor talking to them. But really this is about risk and de-risking your conveyancing department and providing a service to the client that will enhance actually the experience, not from their legal perspective but from a tax perspective, and why it's important for them to understand that their solicitor or their lawyer or their conveyancer is not necessarily a tax expert, and it's really important to get separate tax advice. So obviously, having been in the industry myself for the last 28 years, I'm looking to help solicitors build a big brick wall between themselves and the tax advice that comes in as a natural consequence of any transaction, really. So from that point of view, and starting off generally, what sort of tax issues are you looking at on a day-to-day basis with your team?
So with my team, I think it boils down to two areas. One is stamp duty issues on purchases, on transfers of equity, on people looking to change their portfolio, maybe buy up some additional bits in their portfolio and how best to do that. And then also capital gains tax and inheritance tax issues on sales and on transfer of equity matters.
And so sort of generally speaking, is the assumption, because I think that most clients look at the government website and there's a basic calculator obviously on there, and they think, well, why can't my lawyer just key in the information? Because obviously stamp duty is a self-assessed tax. So something that I'm sure you and your team are always driving home to the client is that it's your obligation to check that you're paying the right amount of tax. And I would suggest that their feeling is well, you work out what my tax is.
I think, yes, and perhaps traditionally when stamp duty was perhaps presented in a more easier way, and I'm talking many years ago now, then yes, I think that's probably correct. But the problem that we have is that there have been numerous changes to the legislation in connection with stamp duty, and it's made it very difficult to advise properly on what the duty should be on any particular transaction. What we've seen is multiple changes, reliefs added in, reliefs taken away. And when you're dealing with complex property transactions, you need to make sure the client has the correct advice.
Yeah. And from, you know, when I had private practice, we looked at terms and conditions, and, you know, buried somewhere in there was probably, we don't give tax advice. But as we both know, we're regulated by the Solicitors Regulation Authority. And I'm not convinced that that's a view that they would take, that your client is reliant on you to give them tax advice in some way. Or how are you making it clear to your client that you're not giving them tax advice? I
think with every new transaction, it's really important to triage it from the outset, okay, and see what the client's trying to do. Okay, if it is a simple thing, like a simple freehold purchase of a property, then I think the solicitor should be able to arrive at the correct figure that should be paid vis-a-vis SDLT. If it's something more complicated than that, then I think you need to put it to the client that perhaps they need to take specialist advice on this. It might be to the client's benefit to take specialist advice because A, they want to pay the right amount of tax. They don't want to find out that they're short and they're contacted by the revenue regarding that. B, there may be reliefs and exemptions that are open to them that they're not aware of right now, which they could take benefit of.
Yeah. And do you think that the client sort of has got to grips with the idea that it's down to them?
No. I think most clients think that the lawyer is responsible for working out the right amount of stamp duty and therefore the lawyer is responsible. But you're right. I always say to clients, you're responsible for this tax. You know, we need you to sign the SDLT1 form. We need you to take responsibility for this tax. We will give you the advice, but ultimately this is your responsibility.
Yeah. And I think that from a perspective of your solicitor or a firm being insured, I mean, I don't know how involved you get with your PI, but clearly the private client departments are giving tax advice, so there must be some cover in place for that sort of thing. But I'm not convinced that we as conveyancing solicitors would be insured to give tax advice.
I agree with you. I don't think that. I think most professional indemnity insurance providers would be worried if their conveyancing law firms that they insure were giving technical SDLT advice that they didn't feel confident in giving. And obviously we're conveyancing practitioners, we're not tax lawyers, we're not SDLT experts. So there is a problem here in that there is a blurring of the lines, isn't there? There is a grey area here where a practitioner feels, can I deal with this myself or do I need to take expert advice? And my feeling is, in that situation nowadays, go and get the expert advice, because for you to keep it in-house and keep that responsibility means that you're then taking the burden of that situation on yourself. Whereas 9 times out of 10, the client is more than happy to go and seek professional advice from a third party, and a third party SDLT advisor that can appraise them of the full situation.
So from your perspective, actually, it's a question of just, I mean, I haven't been in private practice for a while, but I think with clients, driven by costs, or if they are expected to pay an additional fee, do you think that that's something that you've just got to be bold about?
Yeah, I think from the outset you've got to be bold. 9 times out of 10, these kind of SDLT situations where we'd pull in an expert, they're likely to be complex. They often involve high value properties, in which case the cost of getting the proper advice is a reasonable cost to consider in the circumstances.
Yeah. I often speak to solicitors, and they are poring over the manuals that are up on HMRC's site. What's your views on that?
I don't enjoy. My view is I don't enjoy poring over the manual. They give examples in there. 9 times out of 10, you can read the example one of 2 ways, which is normally both ways. You don't know which way to turn.
Yeah,
it's very, very difficult. Obviously, every person's personal situation turns on these particular facts.
Yeah,
you've got to be pretty bold to say, oh well, those facts mirror that part of the manual perfectly.
Yes.
Very, very rarely does that happen.
Yeah.
So in which case, if you're not, then you're kind of just drifting into a grey area of crossing fingers and hoping that you're applying something which is correct.
Yes, and HMRC, obviously, they also say they're not bound by their own guidance.
Well, yes, and to be honest, that's a very good point, because many, many moons ago, you used to be able to phone them and run a scenario through with them on the telephone, and they would say, oh, yes, well, we think it should go this way or that way. But that's impossible nowadays. You used to be able to write them a letter, but I mean the turnaround times on correspondence with them now, I think it runs into months, maybe a couple of months or something.
Yeah. Similar to the land registry sort of times for registering.
Yeah. So I mean, I don't think that's not in a commercially run situation. That's not something you can rely on. Oh, we'll write to HMRC and ask their opinion on this and that for a stamp duty query.
Yeah.
It's just not practical.
Yeah, no, fair enough. And I think as well, it's quite interesting, looking at the cases that are coming through. I think, it's very interesting the way that the reliefs are being applied, the surcharges are being applied. I mean, there was I don't know if you come across it, the bacon factory case that came through at the beginning of the year, and there was planning permission for light industrial on that, and even with planning permission, it went through first tier, and they still rejected the fact that there was that you could apply for relief for mixed use. So actually HMRC won in that circumstance. So I think it's heavily nuanced, and you're better off relying on somebody like our PI than your own.
Absolutely, like any case and any sets of situations or scenarios, it's going to come down to the particular facts, isn't it? So you as a firm could make a decision how you feel the SDLT position should play out. But of course, the tribunal or HMRC might have a very different view. And you're right, by retaining that advice within your firm, you're also retaining the burden and the risk that this could come back and bite you at some point in the future.
Yeah, because I think the other thing that I also find a little bit disconcerting is the way that the SRA define what legal advice is. That looking at their definitions, which was admittedly from 2017, it talks about whether or not you actively facilitate a transaction, and you must be obliged to submit the SDLT1 invariably for your lender. So, and you will be paying the SDLT as well, which feels quite facilitating. So I think the SRA would stand a good chance of saying to your client who advised you in relation to the tax, and your client's going to say, my solicitor did.
Yeah.
And so I think with breaches in regulatory elements as well, so you've not only got the financial risk associated with getting it wrong and not being covered for the advice. I think from a regulatory point of view, I think solicitors need to be very careful.
Yeah, very much so. Holding yourself out to be an expert in something that you're possibly not an expert in is a dangerous thing to do.
Yeah. So from your perspective, you've tended to outsource. So was the decision to outsource a lot of your tax advice purely from a risk perspective, or what have you found the advantages or benefits of doing that are?
I think it's come about through a number of things. One, increasing complexity of the legislation. Two, I think that increasing complexity of our transactions as well, that's meant that we find ourselves more and more in a situation where we're thinking this is complex and needs a proper expert looking at it. Three, we've had some situations where we've dealt with HMRC and it's been difficult to deal with them. And to be frank, I don't want to be in a position where I have to deal with them. So for those reasons, it's made sense to outsource the SDLT function in all but the simplest cases, because then we know that it's being taken care of by somebody that knows what they're doing. And also as well, we know that they're giving advice to the client direct, so that the proper advice is being given as well. Yeah,
and I think that's quite an important point, is that the client, just purely for the tax advice, is not your client. So there's a very clear brick wall between your retainer and what your retainer stipulates that you will be doing, and there then being a very separate retainer letter of engagement with the tax advisor to say what they're doing. And I think working collaboratively with a tax advisor is obviously important for everybody, so that there are those clear lines between who's doing what.
Yeah, and you're absolutely right. It's very useful to know that the tax advisor is providing the advice and has the engagement letter, and therefore that is technically outsourced. We appreciate that we need to understand the advice and work with the tax advisor to make sure that we fully understand what advice has been given, so we can implement that, for example, when completing the SDLT1. And so it's not like we're saying we're doing away with SDLT advice as a firm, or we're not getting involved in it. Of course we are. We're just outsourcing the particular technical parts.
Yeah. And I think as well, if you've then got your, a copy of the tax advice on your file, the client's obviously got their tax advice. So, from a data protection point of view, everything is properly managed from that point of view. But I think that it's good to have your file with your clear risk assessment on it, and then an outsourced tax advice and a copy of that advice that's there. Or, so how do you manage the clients that say, well, I'm not prepared to pay anymore, I don't think I should have to, or I don't need tax advice, I'm going to do it myself?
Well, okay, so I've not had somebody yet query the costs of the tax advice. Most people have said, yeah, fine, I'll go away and do that, and then it's dealt with. In terms of people saying, well, I'll sort it out myself, we have to have a serious conversation with them about whether they feel that's the right thing to do. And sometimes they'll go to their own accountant, of course. You know,
Right,
they may, if they're, if it's a property developer and they have an accountant that deals with all of their property stuff, then he might be well suited just to tack on some advice in connection with a particular property transaction. But I mean, our advice would always be, look, get the help that you need, you know.
Yeah, and keep it away from you.
Keep it away from me, because I don't want to be trying to wing something that I don't feel confident.
And I think that I mean, you know, many of us go to our training to do our CPD, and actually there's not a lot available regarding CPD on SDLT. Not that I've found.
No, there isn't. There isn't, and in fact, I think that the thinking now is that we shouldn't be holding ourselves out as tax experts. That's not the look that's not the right look.
Yeah, and so therefore, which it just lends itself even more to getting it off your desk, really.
Yeah,
I think,
yeah.
really. So, just in terms of like how you feel there could be any further enhancement, what other benefits you could get, what do you feel is lacking? I don't know. Do you feel that the way that you've got things set up now are suiting you in your practice?
Well, it is working. It is working well at the moment, and I think it's working well because we have very little to do with HMRC. Thankfully, you know, our payments are not being queried. We're carefully checking what we do, and we're risk assessing each case. As I say, I go back to our initial point, which is to triage and risk assess when the case starts right at the beginning, and say to yourself, right, look, is this something that we can handle, or is this something that needs to go to an expert? You know, what is the stamp duty position on this? Is it going to be simple, or are there more complicated factors to play here? So I think it is working. I think it is working well. We have had previous SDLT advisors in the past where it wasn't as good as we'd hoped it would be, and I feel our relationship now is a lot better. Yeah,
because I think as well, I think there's an element with the reliefs that they've removed. MDR was a horror for, I think, estate agents drumming up excitement within a client regarding, because if you say to a client, you won't have to pay as much tax, I think that does turn a light on in most clients' eyes, and they then become quite focused on that. To the exclusion of of reason sometimes. And so I think from some perhaps lawyers' point of view, the removal of MDR I think has helped. I'm not sure. I guess at the moment the big one perhaps is like mixed use. Would you say that you're finding that they're saying you should go for mixed use?
Yeah, so that the mixed use is still something, so flats above shops, that kind of thing is still something that people are looking at. You're right about MDR. I'm pleased that that's gone, because people were taking the mickey with that. They really, really were. Estate agents were trying to market properties as being able to claim this kind of relief, where clearly there weren't multiple dwellings there.
Yes. A shed.
Yeah, a shed.
A shed with a bowl in it.
I can give you all manner of examples, and then also then the little cottage industry that span off from that was all of the claims farmers that were messaging us saying, your client, you've made a mistake here, you know, your client should be claiming MDR. And
those are they still, have they gone
away now?
Because obviously the budget brought in the potential for new legislation for the government to create new offences for promoting tax schemes, basically. Interestingly, there's a case, Mudan, with whether or not a home was entitled to claim a relief for being dilapidated, and ironically they paid the full stamp duty to start with, and then I think it was about 4 or 5 days before the end of the annual you could refile. They refiled, having been contacted by somebody to say, oh no, your solicitor should have claimed relief for you here. And of course they claimed the relief and were repaid, I think about 177,000, which they then used on refurbishment. I mean, undoubtedly the property was in a pretty poor state, but the bar for dilapidated homes is so high. And then I think about 2019 they purchased. 2020 they then filed to change their return, and then 2024 came the judgment. So 5 years on, obviously, with the interest and court costs that were on top of that, and then they lost. And that was driven by somebody thinking that they could claim a relief after the event, which then didn't come to fruition. Because, of course, at one time, HMRC were literally saying, you could say, well, I should have claimed MDR. And HMRC were going, oh, OK, well, have your 80,000.
Exactly so, yeah.
And then, raising their inquiry within 9 months and then saying, oh, no, we'll have it back, actually, and then they will issue a closure notice.
We were spending lots of time going over old files where we'd received these letters and just double checking that our advice was correct about MDR, and it was every time. Yeah. And there was silly situations where people thought they could claim and they shouldn't be claiming. Yeah. And that needed to be closed down, and I'm pleased it has been.
And I think as well another good reason actually for, coming back to your points at the beginning, how complex SDLT has got with the changes in the rates, what applies for what, how they define dwelling, for example, in multi-dwelling relief was not how they define dwelling for a dilapidated home, which is not how they define dwelling for mixed use. And I think those sorts of things make it even more complicated and difficult to navigate.
Well, you're absolutely right. As a property solicitor nowadays, we have to interpret environmental searches. We're supposed to now become experts on the climate damage that could affect your property. All manner of things, fire risk assessment, fire cladding, I could go on with, before we even get into leases, freehold, leasehold, whatever.
Before you get to the
contracts.
Legal points.
Yeah. So I think to class yourself as a tax expert is, it's stretching things. Yeah. It really is.
To be honest with you, climate change expert, I mean, that's quite a stretch. I mean, it used to be sort of a client would see an ARGA in a property and that was it. It didn't matter if they didn't have rights of access because they wanted that ARGA in the kitchen. And human beings don't change. It's a very emotional purchasing your home, isn't it? I guess perhaps commercial lawyers will find it easier with their commercial clients. But I think once a client gets focused on something, I think it's very difficult to get them to deviate from that, or to actually suggest to them that this is perhaps not the purchase for them. Yeah. So, interesting. Well, thank you very much. It's very helpful and very interesting, and I do urge all solicitors, lawyers, to really think carefully about the legislation and the implications of doing it yourself, because as I say, I don't think the SRA will be too kind or considerate or, I don't know, even objective if this starts to bubble over, really. I think that there have been examples, and certainly with the SRA looking for unlimited fining powers, I think it's a tricky space to try and operate in, so stay well away if you can.
Definitely, I agree.
Yeah, smashing. All right, thanks for your time, Simon.
Pleasure, thank you.
Thanks for listening, and tune in next time when we discuss more of the tax and legal issues surrounding your business and property needs.